This is an application and an appeal in the matter of Expert Tooling and Automation Ltd and Engie Power Ltd.
Good morning.
May it please my lady, may it please my lords, I appear with Professor Davis and Mr. Turner for the appellant on this matter. My learned friends, Mr. Lord King's Counsel and Mr. Cutting appear for the respondent. Can I just apologise to the court for the delay in starting this case? The Opus team have had difficulties in connecting their system up. When they said they might need another 10 minutes, about a minute ago, I took the executive decision, not obviously it was a matter for your ladyship, for my lady, to suggest we just start, because we've got a lot to get through, an awful lot to get through.
Absolutely, I think that was the right decision, endorsed by me. And although it's wonderful to have it all set up and running, we do need to get on. And in that vein,
Yeah.
I assume that you have agreed a timetable on how to separate out your submissions.
We haven't, my lady, but I anticipate, given that I will open the case and show your ladyship and my lords all the documents which are relevant to the case, that I would finish at 4:30 today, and then my learned friend would have most of tomorrow until 4, and then I'd have 15 minutes of reply, if that's convenient to the court.
Well, first of all, I have to say that we're not able to sit beyond 4:15 today,
Yes,
so please tailor things accordingly. But we will look at the situation then in order to determine whether we might have to sit early tomorrow or something
Thank you.
in order to fit things in. But 4:15 is a deadline for
No, I
today.
understand. I understand.
And as you say, we do have a lot to cover, so let's get started.
My lady, many thanks. The court will have seen that this appeal was originally listed for March of this year, and what then happened was that judgment was handed down in Johnson in first round in October of last year, and more importantly, in terms of the timing of this appeal, the Supreme Court then granted permission in mid-December and then expedited the appeal first in Johnson. So it's to be heard now, as I understand it, for 3 days on the 1st of April. And we then made a joint application, jointly between the parties, to the Court of Appeal to seek an expedition of the hearing of this appeal. Lord Justice Newey considered it and gave a direction, and hence we're here today. And I just wanted to convey my thanks, I'm sure Mr. Lord's thanks, to this court for accommodating. And I know there must have been an awful lot of behind-the-scenes activity to allow this appeal to be heard today and tomorrow. So I'm grateful to the court for that. My lady, the second point that I wanted to make by way of broad background submission is that this appeal has, and I think it's common ground at the bar, has potentially very significant implications for a very large number of cases that are pending before the courts of this country. That point was made particularly by my learned friend, Mr. Lord, before the trial judge in February of last year. And it's a point recorded in my lord, the trial judge's judgment, paragraph 24. And it was partly for that reason, if not solely for that reason, that Judge Saffman, sitting below, transferred the case, which was otherwise pending in the county court, to the High Court. Hence, this is an appeal to the to the Court of Appeal rather than to the single judge sitting in the High Court. And it's right to say that there are a very large number of cases pending, not just against Engie, the respondent, but also against many other energy suppliers.
I'm sure.
Which follow a similar fact pattern, and hence the significance we perceive of any judgment that this court can deliver before the 1st of April. We believe, I'm not in any way making any expectations, I should say, but we believe, I think, at both sides of the court, that the Supreme Court would be very much assisted by any judgment that the court is able to deliver. And the court would have seen the overlap between the decision in Johnson in first round and the fact pattern generated by this case. And the third point that I wanted to make by way of general introduction is that at the heart of this case is the position of brokers, otherwise known as third-party intermediaries, who were at the relevant times, and I suspect still are, critical features and important features in the energy market. Brokers in this market stand between, on the one hand, the customers, on the other hand, the suppliers. They act as agents for the customers, that is now common ground. They go out, or ostensibly go out into the market, acting on behalf of their clients or customers to seek energy contracts for them. And on the face of it, and the advertising material they generate, and particular broker in this case is no different from many other brokers that were operating in the market at the time and no doubt still operate, sets out a number of promises and pitches about how they will act and how they will perform their duty. And what I was proposing to do, before I come to the nub of my submissions, was to just draw the court's attention to the regulatory concerns that have been expressed as to the role of those brokers, and then to take the court through the facts of this case, because those facts are replicated, as I know from personal experience, I'm sure my learned friend knows as well. There are nuances here and there, but they are replicated time and time again. It's important for this court to understand the precise architecture of the contractual mechanism and how the tripartite relationship, and there are three sets of contracts essentially, and how they interlink. So the first point.
I understand why we need to understand the contractual architecture. Yes, why is the regulatory overlay of any significance?
My lord, the regulatory overlay is of significance because it demonstrates that the relevant regulator, being Ofgem, had throughout the relevant period, and it's the material that the court has in its bundle starts at 2008 and goes forward to 2015, that the relevant regulator had, through considerable amount of research, identified within the market certain concerns about the activities.
If you're right, this is a breach, it's a fiduciary duty and there's a breach of it. It doesn't matter what the regulator thinks. Even if there's no regulator, equity would provide you with a remedy.
Well, that is right, but I'm not going to spend too much time on it. I merely mention it simply, my lord, to make this point, that this is not some bespoke event that occurred between three parties in 2016 and which hasn't been replicated on many other occasions. And the fact that the regulator has on a number of occasions identified concerns about transparency with TPIs or brokers, about honesty, about the understanding of customers. And there's a particular, I'm not going to overstress this point, but there's a particular paragraph in the 2008 Ofgem report, which is a bundle, I'm not going to take your attention to it, is a tab 55, where at paragraph 10.23, Ofgem notes that there's a particular concern about customers entering into contracts via their brokers without even understanding or realising they're doing so, and doing so via phone conversations between the broker and the customer, where the broker says, I'm going to lock you in at this rate, are you happy to do that? Runs through a script, and it generally takes a few minutes, and without customers necessarily knowing it, they find that they have then been entered into, so to speak, a contract via the agency and via the letter of authority of the agent. I don't want to overstate.
Mr. Grant, thank you for that. I think you can assume that we've all read very widely, first of all. Secondly, I think that unless my Lord Justice Zacaroli thinks differently, I think going to the Ofgem details is not necessary now.
I won't do so.
And that therefore, although we have read widely, you can take us quite quickly through the elements of this contractual arrangement, although you must assume that we have read it all before.
I'm grateful. My lady, can I just...
Do, I think, need to move to the
yes,
the nitty-gritty.
My lady, can I just, because it's something my learned friend will rely upon, can I just show the court tab 61 of the supplemental bundle? It's the last tab of the bundle. It's page 336 of the supplemental bundle. It's a two-page Ofgem document headed third-party intermediaries, what your small business needs to know. It was published in 2015, and it sets out information for small businesses as to how TPIs operate and how typically they are remunerated. We see that at page 337. My lady,
How is this relevant? Does it go specifically to fully informed consent, or?
my lady, the reason I don't say it's relevant at all.
Well, let's not look at it then.
But the reason I'm showing it to the court is because the judge below had treated this document as, so to speak, in the public domain, and had and it's said by my learned friends now that my client should be, to use their language, treated to have known about this document, and therefore it is, so my learned friends say, relevant to the question of fully informed consent. I don't rely on it. I simply, out of fairness, show it to the court because my learned friends rely on it. I'd say no more about it.
Okay.
I go to the paradigm facts of this case, and I'm going to spend a little time on that. I'm conscious, I'm very grateful for my lady's indication. There have already been at least 3 trials in this area. In fact, there have been many more, but we haven't dumped all the judgments, all the county court judgments on you. You have in your bundle, for what they're worth, and I'm saying it in a non-pejorative sense, four county court judgments that have passed through the courts previous to today. And what they demonstrate is that there is a clear fact pattern that replicates itself time and time again. And that fact pattern has a number of key features. The first feature, my lady, is that what will typically happen, and happened in this case, is that a broker, in this case Utilitywise, will approach, by way of a cold call, a customer, either by telephone or in person.
Before you go any further, you are talking in general terms, and I'd be grateful if we could just stick to precisely what happened here.
Yeah, quite.
Because if that is not in the case here, then we're going to get mixed up.
Can I make very clear, everything I'm saying
Does apply.
is replicated here,
Good.
actually happens here.
Okay,
And
so cold call.
There's a cold call, and for the court, I'm not going to take the court unless you'd like me to the relevant references in the bundle. But that is made clear in the evidence put forward, served and adduced by my client. But it is also confirmed by, perhaps more importantly, Mr. O'Connor, who was the sole witness for the defendant at trial, and in particular at paragraphs 23 and 25 to 26 of his first witness statement, which is at tab 8 of the supplemental bundle.
Paragraphs?
23, my lord, and 25 to 26. Mr. O'Connor sets out how, in his understanding, and he was the interface, so to speak, for Engie with the brokers, he explains, we accept his evidence, that how typically brokers act in the market and how they acted here. And in particular here, Mr. Forster, in his witness statement, I don't think he was challenged on this, recalled how the broker in this case was, quotes, very pushy. That's Mr. Forster's witness statement, paragraph 12. He also recalls in his statement, again, I don't think it was challenged, that he invested trust in the agent, paragraph 16. And my lady, we have, in this particular case, we have 2 recordings of telephone calls. I'm going to come back to those recordings. But as regards the second recording, which is for the 29th of January, that's the phone conversation, which is with Mr. Gaisley, who's the factory manager in the Northeast, in Sunderland. And it's all the contracts relate to that particular factory. And what is common ground is that the broker, having spoken to the gentleman in Coventry relating to the Coventry contracts, which occurred in 2015, then phones Mr. Gaisley, who, in his evidence and is not challenged, receives a call simply out of the blue. He has no idea who he's speaking to. And there's a 10-minute call. And literally the next day, or perhaps further that day, I should say, the broker then signs a contract in a particular amount, which we'll look at. So that's how the broker approaches the customer, replicated here. The second proposition, my lady, relates to the way brokers pitch themselves to their market. And here we have, in the supplemental bundle, a printout of Utilitywise's website, or part of its website, at the relevant time. That's tab 14 of the supplemental bundle. Again, I won't take the court to it unless you care to do so. But what we see in the website is a number of propositions being made by the broker to its potential customer base, which, as the court might expect, involve a number of propositions about we're on your side, we're independent, we are acting to get you the best deal, and so on and so on. And my lord, my lady, at paragraph 4 of the judgment below, Judge Saffman quoted from another website or aspect of the website, which is not before the bundle in the court's bundle, because we didn't want to overstretch the court's bundle. We see at paragraph 4 some further quotations from in the judgment from Utilitywise's website. So,
And did Mr. Gazeley and his colleagues see the website?
they did not, but the reason we rely upon it is because if one then goes to Mr. Forster's witness statement, especially at paragraphs 12 and 16, he refers to the fact that over the various conversations he had with Mr. Jackson, who's the gentleman from the broker, he is told by the broker, we are striving to get you the best deal, we're on your side, and words to that effect. And he trusted them. And who can blame him? When plainly, and obviously, that is the way that a broker is going to seek to pitch its services to a customer, because after all, it wants to acquire customers and wants to earn commission via, so to speak, those customers. We'll come back to commission.
Well, I would have thought that's what the broker does.
Yeah, quite. My lady, the next step, or the next proposition, is that the broker will obtain a letter of authority from the customer. And those letters of authority are, by my experience, relatively similar in content. Critically, what they do, or what they did in this case, and often do in other cases, is they give authority to the broker to go out into the market, to represent the customer, to provide to the market or the potential companies they've approached details about the customer, and also to obtain details from its existing energy supply about what rates it's on, the nature of the contract it's on, and so on and so forth. And critically, in this case and in many cases, to contract on behalf of the customer with the supplier. So it is what has been described below as a paradigm agency, i.e. an agency in the strictest sense of the term, i.e. whereby the customer, the principal, gives authority to the agent to contract on its behalf. And my lady, in this case there were at least 3 letters of authority signed. The one that is relevant to our case is at Core Bundle, tab 23, page 204. I won't take the court to any of the documents unless I'm asked to do so, save on certain occasions.
Page reference again is 24.
I do apologise, my lord. It's page 204. 204 of the core bundle, that is. Would the court be assisted by me going to it?
No, it's the same one that appears in the supplemental bundle of 170.
It may well be, my lord. It may well be. And that is what happened here. My client signed a succession of letters of authority, and it was a contentious question at trial whether my client had, whether the broker was indeed my client's agent. That question was resolved in my client's favour and is not challenged on appeal. Just pausing there and moving on to another proposition, again apparent here. TPI's brokers were vital to Engie's business. Mr. O'Connor himself, at paragraph 7 of his witness statement, makes that position very clear. And it looks like the vast majority of the business that Engie was able to do, it obtained via brokers. A broker would phone them up or contact them and say, I've got a customer, what's your price? And a contract would be entered into via the TPI. So at least from Engie's point of view, the respondent's point of view, the brokerage system was vital then, possibly still is now, to its business. And secondly, of course, it is now common ground, I think it might have been common ground at trial as well, that the company Engie, the supplier that is, knew, because of course it was obvious from the letter of authority, that the broker was acting as agent for my client. And indeed, Mr. O'Connor expressly admitted that in cross-examination. For my lady's note, that is supplemental bundle, page 77C and 87G. That is the admission and the acceptance, as was inevitable by Mr. O'Connor, that he knew, and that Engie knew, that the broker in this case was acting on behalf of my client as its agent. Now, the next thing I come on to, the next part of the chain or the jigsaw, is the relationship between my client and the broker. The first of the three arrangements in this tripartite overall arrangement. Now, there was clearly a relationship and a contractual relationship between my client and Utilitywise. And Utilitywise purported to contract with its customers, including mine, there's a question mark about that, but I'll come on to show you what the evidence demonstrated as to whether its terms and conditions were incorporated or not, and whether or not we knew about them. Now, there is no evidence at all that Utilitywise provided my client at any stage with its standard terms and conditions. The witnesses that were called on behalf of my client both said at trial they had not seen the terms and conditions, nor had they read them, and nor had anyone overtly pointed them out. I think that's common ground at the bar, that is the case. But what the defendant relies upon and relied upon at trial is the email footer contained in Utilitywise's emails. And we see an example email from Utilitywise at tab 17 of the supplemental bundle, page 224. It doesn't matter, this is just a random email. It doesn't matter what the email is. It's the footer that counts. It's an email. We see Mr. Dean Jackson, he's the gentleman who phoned my client twice in the transcripts we have. And you'll see the footer concerning the standard terms and conditions. Right at the bottom of
Tab 16.
Tab 17, in fact, my lord. Page 224.
So its terms and conditions can be found at a particular place on the website.
Exactly. Exactly right. Now, it's relevant just to interpose here the view of the Court of Appeal in Johnson, where a similar point was run by the defendants, where the Court of Appeal in Johnson took the view that it was obvious that no one was ever going to download those and look at them. And that's, I accept in a slightly different
Sorry to
context.
interrupt, but this is not a page I'm finding, so which
Oh
is
dear,
the
my lord,
supplemental bundle.
This is concerning to me that your lordship does not have page 224 of the supplemental bundle.
Well, I do, but it's a tab. I've got the wrong supplemental bundle. It's tab 27. Right?
Correct. That is, I do apologise, my lord.
So tab 7, you said tab 17.
Tab 17 of my bundle should be, I'm just looking behind me to make sure it's not me that's going wrong.
224 does pull up on my electronic bundle at least.
Tab 17.
Yes.
My lord, I do apologise. I don't know why your lordship has such a...
Actually, sorry, it's,
Yep.
yeah. 224. Yeah.
Does your lordship have 224 as that footer?
No, but let me look in the electronic section.
Well, I do apologise.
There have been various bundles provided then withdrawn.
It's fair to say that Lord Justice Lewison took a rightly harsh view of our over flappy original
I
budget.
shall work on the electronic bundles, and so it's fine. No,
Can I hand up a
don't
new
worry,
one?
I'm going to use electronic.
I do apologise.
Um,
So
But can I just say this, that it isn't just a footer, is it? Because, although I have to turn the thing on its side, it does say, please note that if you have returned a signed LOA, you're going to be bound by this
no,
condition.
that I absolutely wasn't seeking to evade that
Yes.
fact. No, that when I said the footer, I meant the totality of those two paragraphs. And just to interpose, in Johnson, paragraph 139 and 173, we'll come back to look at Johnson, of course. It was suggested that in the real world, no one would ever look at those, and I respectfully agree.
But are you saying that means they're not part of the contract?
Well, my lord, it's no part of my case whether they are part of the contract or not.
Right.
It is because the contract doesn't. It's not as if there's a contractual defence being run here. The only issue to which this goes is, as I understand it, it's of course the burden being on my learned friend. Was a trial. Is fully informed consent, and so it's not the question of incorporation. I think is a secondary one.
It might go to the what it was that UW was promising to do. I don't think I've seen the terms.
We're going to look at them precisely now, my lord. As I say, just to recap, Mr. Force. No one suggests that Mr. Gaisley ever saw them. His entire involvement in this case was a 10-minute phone call on a Friday afternoon when he was anxious to get home, and Mr. Jackson emerges out of the blue and speaks to him for 10 minutes, and then he disappears home. Mr. Gaisley's involvement is transient indeed, although it led to the 5 contracts that were sued upon. Mr. Forster, who'd had more involvement with Mr. Jackson, gave evidence, and no one challenges it, that he never looked at or seen or read the T's and C's, but nonetheless we should look at them. I slightly we find them at core bundle tab 31, and I will in order to save, if possible, my learned friend having to go back to them, I will show you all the even potentially relevant terms and conditions. My lady has them at tab 31, page 266. On the front page, you'll see utility-wise terms and conditions for the supply of service. The customer's attention is particularly drawn to the provisions of clause 6, 2/3 of the way down the page. We might look at then, if my learned friend wants me to look at something which I've evaded, of course I've been invited to mention it. Over the 267, my lord, my lady, my lords will see the letter of authority is defined. I think the court has seen the letter of authority. You see the customer is defined, and the contract is defined, and the services are defined. It's fair to say there was no schedule of services that we're aware of that was sent to us by Utilitywise. That's 267. We then
But
go
you're
to,
saying that the T's and C's altogether weren't sent to you?
yes, we are.
Yes, exactly.
I
I'm
don't think
sorry.
anyone
It's just
suggests
that
otherwise.
you said something which implied perhaps that it was only the schedule that hadn't been sent. I was slightly confused.
I apologise.
Let's move on.
My error.
But the way that, at least in theory, this could work according to the terms is that a schedule of services would be the actually important document that would be provided directly by the
Right.
broker to the customer.
A bespoke document.
Yes, and if the customer wanted to know the T's and C's, it would click on the link and find the standard form TLCs, terms and conditions. So
Yes. I'm just simply laying out.
Yeah.
I don't say these TNCs have any significance of any sort to this case, but my learned friend does. So I want to fairly show the court what they say and what they even potentially relevantly say. My lords and my lady will see the supply of services defined at 3, customers' obligations at 4, And then I think in particular over the page at 270, we see the limitation of liability, and the customer's attention is particularly drawn to this clause in black and in capital letters. And I think the relevant or theoretically relevant sub-clause that is relied upon is 6.3 at page 271. And my lady can read that. And then I'll make a brief submission on it. And what is said by my learned friend is, there we are. There's a reference to commission. There it is at 6.3. Ergo, in some shape or form, the customer, i.e. the claimant in this case, was on notice of it or knew about it. I'll leave my learned friend to develop the submission, but I wanted to show my lady, the relevant sub-clause. So in terms of the first part of the relation of the tripartite arrangement, i.e. the relationship between customer and broker, I think I've shown or directed the court's attention to all the potentially relevant documents. The second relationship is between the broker and the energy supplier. And in most of these cases, and indeed in this case, there is an overarching contract between broker and energy supplier. And we can see, and I would like to go to this contract if the court would care to see it. We see in this case the relevant contract for the bulk of the contracts in issue in this case is at core bundle tab 26. And core bundle, not supplemental. It is dated, although it's not on the face, it's dated as the court will see at page 210, top of the page, 25th of June 2015. It is between GDF Suez Marketing, that's no more than the previous name of Engie. It's not a different company, it's just a name change. And Utilitywise, you can see that, the court can see that 209 and 210. And again, I'm going to, if I may, just spend 2 minutes going through what are the relevant or potentially relevant provisions of this overarching contract. This is not, of course, bespoke to the relationship with my client. This is an overarching brokerage agreement, which applies to all business, using that term broadly, between the broker and the energy supplier. We can see in the recitals, paragraph 1, TPI, that's the third party intermediary, that's Utilitywise, is an energy broker who wishes to obtain quotations from Engie and its affiliates for the supply of gas and electricity for and on behalf of its clients, the potential customers, i.e. people like my client. 3 of the recitals, the TPI wishes to charge Engie a procurement commission in relation to the introduction of customers to it. 4, the parties agreed that Engie will provide quotations to potential customers referred to by the TPI on the basis of this agreement. And that the provisions of this agreement are intended to ensure that TPI will act in a fair, honest, transparent, appropriate and professional manner when dealing with potential customers. We can move on. The word commission is defined at 1.1.4, page 211. It's a circular, it's a rather circular definition, but I leave it at that. The obligations in relation to the supply of customer information are provided for at paragraph 2. This is the provision to Engie of information about the customer so that Engie can produce a quotation. That's 2. 3, GDFS, the Engie may at its sole discretion provide quotations to potential customers. So essentially what happens, and happened here, the broker will approach Engie with a potential customer and will seek a quotation for that customer based on some information about that customer, which it provides to Engie, and Engie then provides quotation. Para 4. There is a warranty of authority at 4.1.1. That, of course, is important because, as we will see, typically, if not always, it's the broker itself that signs the contract on behalf of the customer. And then there's a raft of obligations that flow from that. And my learned friends relied upon, and therefore I, in particular, ask your lordship, my lady and my lords, to look at 4.1.8 and 4.1.11.
4.1.4 says all activities of the DPI relating to the agreement to comply with the provisions of all applicable law, etc., and actually mentions the Bribery Act at the top of
It does. I don't think the Bribery Act in this case has any actual bearing, but you're quite right, my lady.
And you were taking us to?
I was going to ask the court just to cast an eye over, because my learned friends particularly rely on them. 4.1.8 to 4.1.11.
Thank you.
So you accept that what went on in this case doesn't fall foul of the Bribery Act?
There was no plea in respect of it, and I'm not going to seek to make that submission now when there were no findings on that. It wasn't any part of the case below. And if that's a convenient moment to move on, we then go to clause 5, which is...
I'm sorry, but before we do move on, you're referring to those because Mr. Lord takes points about them, but what is your position in relation to that? These are requirements that the broker which are being imposed on the broker by the energy company.
Right.
That the broker will act in a fair, honest, and transparent, appropriate way. Do you say that gets one nowhere?
Well, I make I think at least 3 points just to immediately answer my lady's question. Point 1 is that in Johnson we had similar language, and the Court of Appeal were profoundly unimpressed by it. And the point that the Court of Appeal make in Johnson is that if you want to ensure you, the supplier, or the bank in that case, the lender, that the customer knows precisely what it needs to know to give full informed consent, then the duty and the opportunity lies flatly with you as the supplier. This goes just as much goes in this case. Point 2 is that the evidence that Mr. O'Connor gave at trial, it's all in the bundle, the cross-examination in the bundle, as to attempts by Engie to ensure compliance and to ensure that this is actually being done rather than just black and white words on a page. It's very easy to put black and white words on a page. Was that effectively there was one single individual who was ensuring compliance by 150 separate TPIs, i.e. there was no attempt at all in any meaningful way to ensure that those obligations were being complied with. That's the second point. The third point, which is perhaps of greatest significance, is that when asked by counsel then appearing in cross-examination what he expected the broker would or would not do, Mr. O'Connor, with candour, said he would not expect the broker to tell its customer, i.e. my client or any one of its clients or customers, facts about the commission. That was something that he had been cross-examined on in an earlier case, and then a further earlier case. It's all, I will take the court to it in due course. But he was absolutely clear that he did not expect the broker to provide information about the commission. When it was put to him, well, you've contracted at 4.1.9 that there should be transparency. The immortal response of Mr. O'Connor was, as I'm going to show you the court, to be transparent does not mean to disclose. A new conception of the concept of disclosure may have been introduced to the English law at that moment. So the reality was, these are just words on a page. And when asked by me in an earlier trial, when I was counsel at first instance, well, why not? Well, why would you not expect them to provide information about the commission, them being the broker? The answer came back, that's not how the market works. Make of that what you will, my lords and my lady. So that, but I did want to show the court those paragraphs because they are relied upon by my learned friend. Now, we come on to commission, which is at page 214. 5.1, where requested by the TPI and subject always to provisions of this clause 5, Engie shall pay a commission to the TPI in respect of each supply contract Engie enters into with this potential customer as a result of introduction. The precise nature of the commission is not identified, or how it will work. The mechanism is not identified in this brokerage agreement. But what we see at 5.2 are some hints as to what really happens. And we'll come on to this. The rate of such commission shall be notified to Engie by TPI. First alarm bell might start ringing. Shall be notified to Engie by TPI. So it's not a matter of a matrix. If they're going to buy 100,000 kilowatt hours per year, then you get paid £100. If they buy 200,000, you get paid £100. No, it's just the commission will be notified to Engie by the broker during the preparation of the quotation. And that's significant and important because, as we'll come on to see, the quotation carries inbuilt within it the commission and shall be subject to agreement between the parties. And again, we're going to see what that means in practice, subject to agreement between the parties. And I would invite the court, because I suspect my learned friend would want you to look at this at this moment, just to read 5.2 if the court would care to. And then could I invite the court respectfully to read, well, I'll take the court through it. 5.4, TPI must submit a tax invoice to enable GDFS to make the commission. And then 5.6 and 5.7, the party acknowledged and agreed that the commission to be paid to TPI are based on the potential customer's estimated energy consumption. The parties further agree that they will be entitled to carry out a reconciliation process at the end of each supply contract. And then in the event that the estimated consumption, the actual consumption is less than the estimated consumption, then there's a reconciliation. That's 5.7. So what happened in this case, if I can just give your lordship, my lady, a preview, is that on the 30th of June 2016, in relation to contract 1, which we'll come on to, Engie paid £89,000 to the TPI. That's specifically in relation to contract 1, and that was calculated by reference to 3 constituents. 1, estimated consumption, which is there in the contract, as we'll come on to see. 2, the commission, which we'll come on to look at. You times estimated consumption by commission, and then times 80%. It's a payment on account. Everyone accepts, I think, in this case, that the actual commission you are entitled to as broker, as against Engie, is determined by actual consumption. It's not, for instance, like a estate agency where typically the vendor will contract with its agent that in the event that the agent brings to it a purchaser which it enters into a contract with, then its entitlement to commission arises on the entry into the contract, regardless of whether that contract goes to completion. Here, there was a mechanism for a payment on account by reference to estimated commission, but the actual entitlement is determined solely by actual consumption. So if there is no consumption, there is no entitlement to commission. And here, just to again preview the position briefly, the contract is entered into on the contract 1 is entered into on the 8th of February, and it, to use the language of Mr. O'Connor, goes live on the 1st of April. It's only from the 1st of April that actual consumption under the contract starts. Now, that's all I wanted to show the court concerning this contract, bar one final clause, which is 8.4 at page 216. And that is the confidentiality clause. And I'll just invite the court, if I may, respectfully to read it. Now, before I move on, it's important for me to outline to the court the precise mechanism by which commission was generated and levied in this case. What happens, and we'll see it in action in a second, what happens is that the broker, having obtained its customer, having obtained the customer's consent to it to go out, ostensibly, it doesn't appear to do so in the slightest, but go out into the world and find it the best deal, it alights upon Engie, and under this brokerage agreement with Engie, the broker then, before the quotation is issued by the energy company for agreement or not agreement by the customer, it tells the energy company how much it wants by way of commission. The court might think that this would be a matter for a matrix, for a scale. It's just predetermined. No. The evidence before the court below, and I think accepted evidence, and in fact Mr. O'Connor himself gave evidence about it in his witness statement, as we'll come on to see, was that the broker decides what commission it wishes to obtain in a given contract. And there's no scale, there's no set of criteria, oh, you charge commission X because of these factors or commission Y because of those factors. It's purely a matter, it would appear, of the broker's whim. And from Engie's point of view, as long as it obtains for itself the base price, the price it buys the energy upstream for, and its own profit margin, which is whatever that might be, as a matter for Engie, to determine how much profit it wishes to obtain on a given contract, as long as it obtains that, it is indifferent to the commission that the broker wishes to charge. And it is important at this moment to look at precisely what Mr. O'Connor said about this in his witness statement. And for that purpose, I invite the court to go to tab 8 of the supplemental bundle, paragraph 47, which is page 173. So we see at paragraph 47, under the heading commission, customers do not typically pay a broker a fee directly for their energy procurement services. The broker looks at the energy supply of their commission. When the broker approaches Engie for a pricing proposal, the broker would typically ask for the contract price to include a particular rate of commission. We'll see this in action in due course. Commission is usually specified as a pence per kilowatt hour. The commission would then be taken into account when Engie is putting together a quotation. And then my lady can read on to the end of paragraph 48. And then we go over the page to paragraph 50, page 174. The unit rate proposed by Engie in a quotation, that's the overall rate, a single figure per kilowatt hour, would be sufficient to ensure that Engie could pay the commission to the broker and still make a profit on the supply. And then I think finally we need to look only at paragraph 52. The unit rate of the contract is specified as a pence per kilowatt hour basis. The customer does not know all the constituent elements of the unit rate. For example, the customer would not know the base price of the electricity and Engie's expected profit margin, and nor, it might be said, would they know the element of the price which is constituted by commission. So essentially, the price is made up of three hidden constituent parts: base price, profit to Engie, and commission to the broker. Now, we are going to look at this in action, but I'm looking at it from in terms of the general paradigm, which is Mr. O'Connor's own evidence. There's no contentious in any way. What I'd like to do now is turn to...
Before you move on, so Mr. O'Connor's evidence was that Engie would agree that commission with the broker.
Well, exactly right. We'll see it in practice. They agree in the sense that they don't say, that's a bit steep, perhaps you should go down. They just say tick, and they don't agree it in the sense of yes, that looks like an appropriate figure. They just take it into account. They just say nothing and build it in and send back the quotation.
Well, 53, Mr. O'Connor's statement, the rate of commission included in the quotation would usually be confirmed to the broker by email when the quotation was sent to them. They may never have challenged it, but there was a formal process of confirming.
I don't think, my lord is right, I don't think in this case we see any suggestion of that actually happening. What we see
What's happening? Challenging it.
Of the challenge or the confirmation is just implicitly confirmed, because it is then what happens is a quotation then comes out from, we'll see this in practice in 2 minutes. Can I defer my answer so we can see it in practice? But before we come to an example in this case, I just want us to show the court the final document in the relationship between the broker and the energy supplier, and that is a side letter that was executed on the same day as the brokerage agreement. Tab 27, page 223 of the bundle, of the core bundle, I do apologise.
27, page 223.
I know, yes. That's the core bundle, the supplement bundle. The court will see there a letter Now, I don't have time to take the court through it in detail, but suffice it to say that this letter or side letter, in essence, does this. It involves the payment by Engie to the broker of very large upfront sums to assist it in its campaign, sales campaign as it's described. And that sum is subject to clawback in the event that the broker does not provide to Engie a sufficient amount of new business during the relevant period. The relevant paragraphs are 2, 3, 4, 8, 9, 12. When I say the most relevant, which get to the pith of this document. And my lady, this document was discussed at trial. It was the subject of cross-examination, and his lordship below refers to this document at paras 206 to 211 of his judgment, and he records the admission by Mr. O'Connor that this side letter created a incentive, or one might say a very substantial incentive, on the part of the broker to direct as much business as conceivably possible to Engie, because if it didn't do so, and it didn't meet the target set out in the side letter, then it would have to start repaying sums of money that were paid up front by way of so-called campaign commission, which we see at paragraph 8. Advance commission 2 million, campaign commission 5 million.
This is in addition to the commission paid in advance.
It would
under
appear
the
so.
contract, is it?
It would appear so. Now, just pausing there. So here we have a broker who has, as is now accepted, an agency relationship with the principal, has fiduciary duties of loyalty and strict loyalty to that principal, who has marketed itself to its customers, including my client, as the person who can get them the best deals and who's on their side and who's independent, has secretly, because it's not disclosed to my client, entered into a contract whereby if it does not provide business to Engie, it's going to be liable to substantial financial penalties. To describe that as an incentive to breach its fiduciary duties might be described as an understatement, with my respectful submission. My lady, that's all I wanted to say about that document. I should explain to the court that the brokerage agreement was restated on the 14th of July 2016 at tab 29. The side letter was restated on the 14th of July 2016, that's tab 28. We don't need to go to those because they're in broadly the same terms.
Mr. Grant,
Was it in place for 2017 as well?
The side letter starts on the 14th of July 2016 and it runs for a period until the 31st of December 2016. What the position was in 2017, I don't think there was evidence on that question. But the brokerage agreement at tab 29 was, so far as I understand, applicable from that date throughout the rest. So that captures contracts 3, 4 and 5. The first 2 contracts are captured under the brokerage agreement. I think my lady wants to ask me a question.
just that you said that this side letter and therefore the incentive to divert or direct
Yes.
business to Engie was completely secret. The client had no knowledge of
No.
it.
No, that's common ground.
That's common ground, but the way in which all of this has been dealt with is to use a label which is perhaps not the best, is as a half secret matter.
Yeah. Can I come on to the concept of half secret, because there's a submission,
Of course.
but I'm very conscious of that question and I will not let it fall, my
Right.
lady. That's the relationship then between broker and supplier. The final, and I should say just now, just to help the court understand, Mr. O'Connor himself, helpfully in his witness statement, that's back to the supplemental bundle, tab 8, set out in his final paragraph, 100.3, page 183 of the supplemental bundle, the commission rates per contract. Page 183, paragraph 100.3.
So supplemental one.
Supplemental. And if the court is there, you'll see that for the 5 contracts, differing commission rates were obtained, or I would say just simply required without any form of dissent. And you'll see that the contract ones where most of the money was paid, and you'll see the column upfront commission. That's the payment of the 80% upfront, which was not a matter of contractual provision, I should say. It would appear to be a matter of ad hoc provision. The contract doesn't say, the first overarching contract doesn't say we'll pay you 80%, it just says we'll pay you an upfront commission. The fact that it's 80% appears to be a matter of ad hoc agreement. My lady, columns 4 and 5, reconciliation and commission, are things that I don't think this court needs to trouble itself with at the moment. That relates to the fact that Utilitywise went into insolvency during the currency or before the inception of certain of the contracts, and there was a purported reconciliation, which I don't think we need to trouble ourselves with at the moment. It gives rise to complexities that are unnecessary to the resolution of the key issues on this appeal.
And to
But-
state, am I right, just to say the obvious, these statements of commission or this evidence about commission does not include any part or reference to the incentive commission?
No, I don't think it does. I'm a stranger to this agreement. I don't think it does. My learned friend will confirm or deny it when he gets up, but I don't think it does. In fact, I know it doesn't because that's the actual rate, as we'll come on to see, the actual figure set out in the bespoke negotiations. I use that in the heaviest of inverted commas that occurs in this case. But the critical point to bear in mind is that the rate of it's not a flat fee, the commission. It is a rate whereby the more energy the customer uses, the bigger the paycheck to the broker at the end of the day. And that creates its own conflict, as we'll come on to consider in due course.
Just, I mean, I don't know whether this is going to be helpful or not helpful, but I'm picking up my lady's question
Yes.
to you. This table sets out commission, which you have described, which relates in some way to the consumption.
Yes.
The incentive payment, which I think is described as, was it the marketing, what was it described as?
Sales campaign commission.
Sales campaign commission. That is not determined in any way by consumption. It's just not.
No,
consumption
it's a
at all.
sum paid entirely divorced from actual business being done, but with this sting in the tail that if you, the broker, don't meet targets in delivering us new business.
Yes, but sorry, what I'm trying to just get down is
Yes.
that the targets are, they are not consumption dependent.
They are site dependent. I think they're site dependent, as in that they use the word site, which I assume means another meter.
So,
if you've delivered us another meter.
so we have two sets of payments, both of which, at least in the documentation, have the word commission attached to them.
Yes.
One of which is consumption dependent.
And is bespoke to each contract.
And then there is an overriding payment, which is not consumption dependent, not referable to any individual contract, but reference to some other metric.
That is, I think, right, with this caveat that I mean, putting it at a high level, but at an important level, as Mr. O'Connor conceded and as the judge appears to have accepted, although it's not clear that this translated into any determination that he made, that side letter had a clear impact on the broker. In that,
I understand.
if you're faced with British Gas or Engie.
I think you need to listen to me for a second, because the point I'm trying to get at, and it may be that I'm not getting it.
No, of course you are, very much so.
Fully. From the perspective of a customer, if he was told that there was a commission being paid to the broker, he might well assume that that is referable to his own contract, his own consumption. And in fact, these commissions would be.
Yes.
There is another payment of commission about which he knows nothing, which has nothing to do with his contract in the sense of consumption, but you say provides a very real incentive for the broker not to search the market for any particular other deal, but to put in the way of Engie. So it's not a consumption-related commission that has anything to do with the individual contract that the consumer would be thinking about.
Yes.
He just doesn't know that there's another payment which you say has the result that the broker is incentivized to put him in the direction of Engie.
My lord has put it with absolute exactitude.
So it's a different type of payment, albeit at least internally badged with the word commission.
And that payment is not then visited on the customer, is it? I don't know.
Well, it's indirectly visited on the customer in this sense, my lady, that let's just take this world scenario. Our case, we're in January 2016. The phone call has been had with Mr. Gaisley.
Oh, it's visited on them in the sense that they're not searching the market because they have
That's
an
it.
incentive to put the work the business in a particular place, but the actual payment of these rather
it
large
doesn't feed in.
sums
No, it doesn't.
doesn't feed directly
No,
in
my
to
lady's
what the
quite
customer
right.
is paying. That is what I was just clarifying.
The single point, which I think you
Yep.
probably picked up already, is Mr. Jackson, in January 2016, British Gas, to take an example, is got a very good deal at 10p per kilowatt hour. Engie's got a deal at 12p per kilowatt hour. Which way am I going to go with?
We've got it.
You've got the point.
Yeah, the point you're going to pick up at some point is whether whatever you say about the consumption-related commission and the disclosure of that, is this incentive payment a secret commission or bribe?
Well, we're not seeking recovery of it. So there's no quasi-restitutionary claim in respect of that £2 million. That's not a pleaded issue. We rely on it in terms of A, identifying the conflict, and B, identifying whether or not there had been fully informed consent. And we would say that for there to be fully informed consent to preview a submission I'll make in due course, the principle, by reference to law that dates back many, many decades, and is very well known to this court, of course, makes clear that for fully informed consent to be
So this
obtained,
only goes to fully informed
it
consent.
doesn't go to the
It-
actual cash remedy.
It doesn't go to the nature of the. Well, what I'm really going to drive at is, does this go to issues 5 and 8?
It does, well, it goes to issues 5 and 8 in that it goes to the state of mind of the broker. I mean, issue 5 is a point of law, I suppose. I mean, when I say issue 5, ground 5 is a point of law as to whether it's dishonesty-based liability or not. Ground 8, it does go to ground 8 in the sense that the defendant obviously knew of the side letter,
It's
it
the
entered
point of-
into it,
it's the
and it
point-
knew of, sorry.
It's the point of law that I'm interested in, because there is undoubtedly a difference between the parties as to the correct legal analysis
True.
of the consequences that flow. Even if you're right on all of breach of fiduciary duty, no full and frank disclosure, there's a difference between the parties about the state of mind that is relevant to make Engie liable.
True.
And that depends, at least on one analysis, about whether this fits into the bucket of completely secret or bribe on one hand, or semi-secret on the other. And I'm just trying to fit
Yes, I
in my
understand.
own head this particular incentive arrangement and where exactly it fits in the analysis. And you say it goes to fully informed consent. So does it make the recovery of the other commissions that you're seeking to recover different?
Well, my lord, I have to be absolutely clear with the court that the case was pleaded and argued below on the basis that it was a Herstanger case, to use that phrase, and that it was a half-secret commission case, and therefore it wasn't strictly speaking a case for a bribe proper. I have to accept that.
So this doesn't
push at trial.
So what you've put to us, whatever you think about it, about the incentive payment, which I'll call it the incentive payment, doesn't change the legal analysis in relation to the actual relief you were seeking.
No, it doesn't. We come now to the third limb of the tripartite relationship. That is the relationship between my client and Engie. The start, so to speak, of that relationship actually filters via the broker. And that is, as I told the court, the two conversations that occurred on the 21st of January 16 and the 29th of January 16. The 21st of January was between Mr. Forster and Mr. Jackson of Utilitywise. That related to Coventry contracts which are not sued upon in this case. What Mr. Forster appears to have said is, well, why don't you phone up Mr. Gaisley up in Houghton the Spring, near Sunderland. He's got a factory there. You might be able to sort out his energy needs as well for his factory. And a phone number is given, and Mr. Forster doesn't tell Mr. Gaisley that's happening, and then there's a call out of the blue on the 29th. And to be fair to Utilitywise, he seemed to have thought that Gaisley would have been pre-warned about this call, but he hadn't been. And I think it's a opportune moment just to show those transcripts very briefly to the court. And they are in the supplemental bundle. They are to be found at tabs 10 and 11, supplemental bundle, starting at page 188. And they are short. They involve Mr. Jackson, in both cases, reading through a preordained script. It's important to recognise that the first phone call relates to a contract which is not an issue in this case, a gas contract in Coventry, which is not suitable. The one passage that my learned friend relied upon, which I need to show the court, is at page 195. It's at the bottom of the page. By reference to the timing, it's 5 minutes, 23 seconds. And it is that passage that is on which reliance is placed by my learned friend. I'd invite the court to read it carefully. Just those 4 lines, I should say. 5 lines.
So that's in relation to the conversation which doesn't count.
Well, it shouldn't count because it's related to Coventry.
Yes.
But the judge somehow aggregates the knowledge in some way which I don't immediately
So we should be looking at divider 11, should
we should, but my lady, before we do so, because I want to be fair to my learned friend, and if we can get away with not looking at this again, we're going to assist everyone. The judge listened to the tape, as I have done, and frankly, it's garbled. We're hardly talking about clear enunciation of a position. Craig Forster, as he said many times before, okay, right, yep, says yep. And it is, I should say, it's relied upon by my learned friends to say, here we are, in the realm of fully informed consent, the FI judiciary is telling its principal that the commission will be paid by the supplier, and it will come as a part of your bill. And we say, obvious, with respect, obvious nonsense. It is garbled language, and Mr. Forster himself, so far as it's relevant to this court's determination, made clear that he did not understand those words to mean that for every £100 of usage or consumption of electricity or gas or whatever it might be, 25 of it or 30 of it or whatever it might be would go essentially be being paid to Engie to end up in the pocket of the broker.
Where are we precisely on this appeal, though, in relation to this point? Because the judge did appear to make a finding, didn't he, that there had been disclosure.
Well, I wouldn't accept that.
Well, I want to know whether he did, and whether you're then challenging the finding
Well,
fact or some other.
The judge said at paragraph 18. Would it be convenient to just go straight to the judgment on this? It's tab 9 of the core bundle. I think it starts at paragraph 54, my lord, where he listens to the tape and slightly glosses it. That's paragraph 54. Then we can go straight to paragraph 187. Where the judge makes the point that it's not the clearest description. We're talking about those 4 lines. But in my view, it gives the flavour that the commission is part of the unit cost. I challenge that, but in any event, the flavour is no good from a fully informed consent point of view, in any event.
It's not. That's not a finding of fact.
No.
It's
I mean,
it's an evaluative
Quite.
view of the fact. The fact being the words of the conversation.
The conversation's there to be, and I mean, I doubt the court will particularly want to listen to it, but you know, the tape is available to listen to. I'm not going to start trying to foist it upon my lady and my lords, but there it is. It's in a relatively casual conversation between two men, and what the court emphatically does find is that Mr. Forster did not understand those elliptical words to mean what the defendant wants to ascribe to them, the meaning the defendant wishes to ascribe to them. In any event, of course, Forster's not entering into the contract in relation to Houghton Le Spring. He's down in Coventry dealing with the Coventry factory. It's Gaisley who's up in Houghton Le Spring, and through some legal mechanism that is not immediately obvious to me, his lordship below elides, basically says that Gaisley's knowledge should be taken to include Forster's knowledge, which is just, I would respectfully say, is wrong. But what we do know,
Well, so far as corporate law is concerned, it's fairly trite law. You can't aggregate two different individuals within a corporate organisation and say their collective knowledge is the knowledge of the organisation, unless it was actually shared.
my lord, quite right, but go to paragraph 202 just to see what the judge actually did say, if you wouldn't mind. Gaisley can be taken to know what the claimant knew and what that included what Forster knew. It's just wrong. But my lord, just finishing up on this point, and to answer my Lord Justice Zacaroli's initial question, para 197, the judge accepts that neither Forster nor Gaisley say they appreciated, in fact, that the commission will be funded by the claimant. Just pausing there, my lord, they understood that the defendant, that they weren't paying the commission and that Engie would pay the commission. I don't want to, that's common ground. And as we will see, when we come to look at this judgment in a bit more detail, essentially the judge's way of dealing with the ignorance of Forster and Gaisley, in particularly Forster, because Gaisley was told nothing, as I'll come on to what
Sorry,
Gaisley was told.
I wasn't sure I just caught what you just said, but I can see it just on the screen in front of me. But you say it's common ground. So you said, what's common ground about who knew what?
What's common ground is that the Mr. Forster and Mr. Gaisley at trial both accepted and were open about this, that they knew that the claimant was not going to pay a commission to Utilitywise, and they knew a commission of some sort would be paid by the defendant to Utilitywise. Both of them, I think, said they understood that would be a payment made, so to speak, by the defendant out of its own resources, rather than somehow funded by the claimant. And what the judge says about that at various stages in the judgment is words to the effect of, you had no basis for that assumption, you should have asked, why weren't you more curious, and phrases to that effect. We see that dotted around throughout the this section of the judgment, i.e. the section ending at 202, and we say that's just completely misunderstanding the law with respect to the law of fiduciaries. But that's to preview a submission I will make in due course. My lady rightly says that the real transcript we need to concentrate on is that of Gaisley and Jackson. That is the transcript we see at supplemental bundle tab 12. And there, all that is said about commission, I can hopefully avoid the, is at page 211. And I've momentarily lost where it is in the page, and I'm going to be told by my learned juniors where it is in the page, 211. Sorry? About halfway down, says Professor Davis, thank you. That's, yes, it's quite, Dean, this is halfway between the hole punches. Dean, right, the supplier might not accept the contract. You are aware as a consultancy we do get paid commission from the supplier as well. Is that okay? Phil, yes. That's all that's said relevantly about commission, or at all, in the second conversation. And as my lady rightly says, it's the second conversation that counts, because Gaisley's the man in Houghton Le Spring. All the contracts that are sued upon relate to Houghton Le Spring, and the first contract is entered into off the back of this conversation, literally later in that day. Mr. Jackson is very quick on the mark, and we can see why he's quick off the mark when we come to look at the actual documents.
And just to be sure, you're not challenging any finding of fact, presumably, but what you are doing is relying on that and saying on that basis there wasn't fully informed consent.
My lady, there were no contentious facts in the case.
No.
The conversation, all the documents were self-speaking. The transcript was there. It was not as if it was a he said, she said case. Everything the judge says is by way of evaluation of uncontentious fact.
Yes, and you pointed to the fact that he said flavour and then actually set out what had been accepted by the parties.
Quite.
The witnesses.
For my lord's note or my lady's note, the cross-examination of, so far as it's of any relevance at all, I say it really is not, Forster's evidence about what he understood Mr. Jackson was saying and what he understood, which was that Engie would make a payment from its own resources to get a valuable customer, is a supplemental bundle, page 26 and 41. That's the cross-examination. I'm not going to go to it then.
So 26 and 41.
That's just the pagination of the supplemental bundle where Forster gives evidence about that particular aspect of the conversation which I've shown the court.
The judge did the judge make a finding as to Mr. Forster's understanding? It may be irrelevant for other reasons, but did he make a finding about his understanding? Because 197 is not a finding about anything.
Well, I don't think he made an actual, I don't think, unless my learned juniors are going to tell me I'm wrong, I don't think he made an actual finding about it. I think he said various words to the effect of, oh, well, you know, why did he had no basis for thinking that what he actually said he thought, or, you know, he could have asked. But that's an evaluative question. And involves a misunderstanding of the law, as I've come on to suggest, respectfully. And just to pick up a submission I made a little earlier, just for my lady or my lord's note, the reference in the cross-examination to O'Connor accepting that he didn't expect the TPI, the broker, to disclose facts about the commission to its principal, its customer, is at page 81 and 82 of the supplemental bundle. That's part of the transcript of the trial, 81 to 82. Now, with that introduction, we can now go straight to the actual contract number one. And how, my lord, yes.
Going back to 197, my lord,
Yes.
just put to you of the judgment. Is the judge accepting as fact that neither Mr. Foster nor Mr. Gaisley appreciated that the commission would be funded by the claimant?
I think he is.
And he's accepting as a fact that their state of mind was that they assumed it would be absorbed by the defendant as an overhead.
But then criticising that. Sorry,
Yeah,
unless
he
I
then-
took it.
yes, he then goes on to say, well, they didn't have any grounds for making that assumption. So he does appear to be at least saying, if it's relevant, the state of mind of Mr. Foster and Mr. Gaisley was as follows. I mean, that is a finding of fact.
And it's a finding fact which is in my favour.
Yes. Okay, but
But-
at
but
least
wait,
that is a finding of fact.
But what he then does against me or against my client is to say, A, you had no reason to assume that.
Yeah, you say that doesn't matter.
And you know, these are These are gentlemen, you know,
I'm
on the
sorry,
shop floor. They're not engaging in metaphysical speculation about commission structures.
That's fine. I'm just trying to make sure I have it in my head, the answer to my Lord's question to you, which
My lord, there's a second answer he gives, which is at 199, which is the assumption that the commission will be funded by the defendant, i.e. the assumption that Gaisley and Forster made, is not supported by information in the public domain. And that's the apparent relevance of that document that I showed the court an hour ago, the fact sheet. And my learned friend Mr. Turner will make a few submissions about that element of our appeal, which is ground 4, in due course. But there it is on the page at 199. Now, I come on now to the actual, within this, the third limb of the tripart arrangement, I come on to the actual way contract 1 was entered into. And it's replicated throughout each of the contracts. But I'm not going to tire the court with going through each of the contracts. Contract 1.
Before we go here, could I just say, Mr. Blunt, that I'm very concerned about the time.
Yes.
We spent a huge amount of time so far on what is the structure and the background, and we have a lot of really quite challenging issues to deal with. So perhaps we could do this quite.
No, I do appreciate that point, my lady. Though I take some comfort from the fact that I think the court has been assisted by this process and has been asking, if I may say so, very pertinent questions in respect of it. But of course I accept that. The email that incepts the first contract is at tab 13 of the supplemental bundle. Tab 13 of the supplemental bundle. And it is sent minutes after Dean Jackson's put down the phone to Phil Gaisley. You can read it in landscape. Jackson then writes to Ms. Major at Engie, copying in various people. Hey, I hope you're well. Can you please lock in the following? This is in relation to the first contract of Houghton Le Spring. Commission to Utilitywise is 5.6 pence. Contract start date 1st of April. Method of payment direct debit. Number of meters 1. Annual consumption, whatever it is. Ignore the next set of bullet points. They relate to a different contract not sued upon. It's the first set of bullet points that counts here. And there we see O'Connor's evidence in action. Commission to Utilitywise 5.6p. Not can we have 5.6p by reference to the following criteria or the following factors. It's just, there it is stated. And what happens then, my lady, is that the contract is then issued, which is initially issued as a quotation, but then that matures into a contract when it's signed by both parties. And the contract is at same bundle, tab 17. Core bundle, I'm so sorry, core bundle, I do apologise, core bundle, tab 17. This is the contract. And it's issued on the very same day, the 29th of January, which is the same day as the conversation with Gaisley and the email. And it is what your ladyship needs to bear in mind there with respect is start date, top of the right-hand page, the relevant supply location, Mercantile Road, Houghton Le Spring, the rates, day rate 17.82 pence, night rate 15 point whatever percent, pence, estimated consumption 2 million, signed by Moslemi, who is a employee of the Utilitywise on the same day, sent back, because of the way it works is that you make the offer, technically it's the customer that makes the offer via the broker, and then accepted by Niall Irwin, who's no doubt an employee of Engie, 10 days later or so. So to be absolutely clear what's going on here, the 17.9 pence is a figure which has built into it, penny for penny, the 5.6 pence. So to be very clear, if the broker had felt a bit more moderate and generous towards its client, its principal, the subject of its fiduciary obligations that day, and said 5.6p for half an hour's work seems a bit steep, let's go for 1 pence, then the price that would have come back would have been 4.6 pence lower. So the price that my client is paying is directly referential to the greed or otherwise, the largesse to itself or otherwise of the broker. And we respectfully suggest that is a most extraordinary situation. And of course, if it's a 1-year contract, then the commission that's going to be charged is going to be a fifth of, or broadly speaking, a fifth of it's a 5-year contract. And of course, therefore, that incentivizes the broker to say, look, good idea to lock in for 5 years, Phil, because who knows what the market's going to do, knowing that that will generate him, I should say, the utility-wise, 5 times the commission, or broadly speaking, 5 times the commission than if the contract was 1 year alone, because it is absolutely consumption-based. This is all common ground. It was accepted by Mr. O'Connor at trial. The judge records that at paragraph 92 of his judgment. It's important, though, while we're here, that I show the court, it may be quite difficult to read, in the middle of the page, there is some boilerplate language. If on the first of the paragraphs of boilerplate, the court may just about be able to discern the words, if you use a third-party consultant or broker to negotiate your contract, the prices quoted may include commission due to them.
I don't have that. Which page are you on?
184, this
Yes.
is contract 1.
Exactly. And where are those words?
I quite understand my lady finding it difficult to
Oh, I
find.
found it. Thank you. I'm sorry.
And that is relied upon, I should say, by the defendant as showing, I think, full disclosure and consent for the purposes of the fully informed consent test. And I'll come back to this briefly, but we respectfully differ from that. Of course, the question arises, just while we're here, the prices quoted may include commission due to them, but which prices? Because we've got day rate and night rate at the top. But if my lords and my lady go over the page, there's a whole bunch of other aspects to the contract, which are not simply consumption-based, price per kilowatt hour based, but there is a standing charge, there's a capacity charge, there's a total distribution network charge, and so on and so forth. This replicates itself across all the contracts. Who knows?
And in fact, the price quoted did not include the incentive commission.
No. Now, very briefly, the first 3 contracts, which are at tab 17, 18 and 19, are all signed by Moslemi, the gentleman at Utilitywise. Contract 4 was signed by an employee of my client, and therefore we can't say we didn't see that, and we don't say that. And contract 5 was also signed by an employee of my client. As regards contracts 1 to 3, Mr. Gaisley said he had never seen any of those 3 contracts. Gaisley's position, his blissful ignorance, was he didn't even think a contract would ever be entered into without him actually signing something. He gives evidence about that he thought this was just all a discussion on the phone and he'd be sent documents to sign, and nothing was ever sent, and he never gave it any further thought and went home and got on with his life. I accept that a binding contract was entered into. I'm not challenging that. But it's Gaisley's state of mind that is maybe potentially relevant. He didn't understand that a contract had been entered into, and he'd never seen contracts 1, 2, and 3. The judge did make a finding on that, which I don't contest, which is that although there was no evidence that the contract was ever sent to my client by Engie or ever received, there's no documentary evidence either way, on either side, the judge made a finding that it was probable that the contracts were sent in some shape or form to somebody at the claimant, although he didn't doubt that Gaisley had not seen them. That's as far as it goes.
Paragraph.
That is a valid question. I think it's paragraph, thank you, 192. Thank you very much. Para 192, my lord. So receipt of the contracts is dealt with in that, on that page, in that paragraph. The only other contract, the only other negotiation I'll briefly take the court to, I think we can then leave it, because it replicates itself again and again. The paradigm which we find here on all 5 contracts is not a negotiation about commission, because of course the Engie doesn't care. All it wants is its base price and its profit margin. Each time the commission is X, whether it's 5.6p or some other pence. But let's just briefly go to the second contract and then leave it. Because the second contract is at tab, it takes us to supplemental bundle tab 17. Back to the supplemental, please. This is now 4 months later. We're now in May 2016. And remember this, my lords and my lady, the first contract is a 5-year contract. So we're not having to worry about anything until 2021. But here is Utilitywise thinking we can bag another £10,000 worth of commission by entering their client, my client, now, into another 6-month contract starting in 5 years' time. And what conceivable reason would there be to lock in your unbeknowing customer to a 6-month contract incepting in 5 years' time? We see the reason because my lords and my lady will see the uplift. Not content with 5.6p, which is about 39% of the original contract and generated an £89,000 commission payment for what must have been half an hour's work, they go for gold now at 6.3 pence. Why is it 6.3 rather than 5.6 or 1.3? No one knows. It's greed, my lady. It's pure greed and it's pure opportunism. We can generate, as they did, another upfront payment. Obviously, it will be the subject of reconciliation in 5 years' time once that 6-month contract is over. But what it generates upfront, as is common ground, is about £10,000 paid into their pocket for, in that case, what must have been 10 minutes' work. And we say, I don't want to start being too hyperbolic, that is quite an extraordinary state of affairs that is demonstrated by this case, and it is replicated time and time again in these type of cases. Commission being simply chosen by the agent without any form of rhyme or reason, and the supplier doesn't care because they're not paying for it. Ultimately, the customer is paying for it because it gets added penny for penny onto the contract price. And
there's a confirmation the customer is aware that there's a fee included, and we are providing the customer with energy services. What does that last bit mean?
What it means is it's just a load of nonsense. What it means, my lord, because what we see in the transcripts is Mr. Jackson, Dean Jackson, saying, "Oh, and we can get you a smart meter, and we can get you this and that." All sorts of fluff about the supposed services that Utilitywise is going to do. Nothing ever happens.
Who's the we?
We is Utilitywise.
So what energy services do they provide?
None. None. It's all fluff, my lord. And to say I can confirm the customer is aware there's a fee included, well, there was no conversation between Dean Jackson and anyone at my client prior to this email of the 4th of May. It's just simply him thinking on a Friday morning or whatever day the 4th of May was, oh, Utilitywise were good for expert tooling were good for 100,000 6 months ago, or 89,000 5 months ago. Why don't we bag ourselves another 10,000 out of them as well? And to finish off my survey of the relevant documents, we come finally to tab 25 of the supplemental bundle, where this is an email, forget about the header, an email from August 2017, which relates to the following circumstances, which are common ground. Even Engie started getting a bit queasy about the kind of commissions that Utilitywise and potentially other brokers were awarding themselves, printing their own money, one might say, and they imposed a cap in May 2017. And that cap, amazingly enough, had the effect of driving all business away from Engie. Because, of course, the TPIs weren't there to get the best deal for their client, they were there to get the best commission for themselves. So all the business was driven away. Engie were obviously quite concerned about this, given their heavy dependence on TPIs. So an email is sent by two members of the High Command of Engie, and we can just see what they think about the previous arrangements.
But before we do that, is this in the judgment, and what relevance does it have to the grounds of appeal?
It is referred to in the judgment, and the relevance it has is showing the perception of the defendant itself to the type of commissions being allocated and awarded by the brokers to themselves. Champagne deal, first line, and then right, if your lordship, my lady goes right to the bottom of the page, to the second bullet point, 4/5 down the page, they're worried, they're having to up their cap to try and get more business back again. We would still remain ethical as we retain a cap and limit the exposure of the customer to extortionate rates. So they were quite aware that the rates prevailing for May 17 were, quotes, in their language, not mine, extortionate.
And where's this in the judgment?
Paragraph 93, my lord, my lady.
Yeah.
That's tab 9, page 193. Mr. O'Connor did not seek to distance himself from that assessment, paragraph 93. Finally, that concludes my survey of the facts. Now, there was a trial, a 2-day trial in February of last year. 3 witnesses were called, Mr. Forster, Mr. Gaisley on my side, Mr. O'Connor on my own friend's side. The TPI had originally been a defendant to this claim when it was originally issued. It went into insolvency and was then subsequently dissolved. It was therefore not a defendant to the trial, and no witnesses were called from who were employed by Utilitywise. My lady, the 3 things that are common ground and were decided in my client's favour by the judge are as follows, and are not challenged or by way of respondent's notice. 1, it was agreed by the judge and held that Utilitywise was my client's agent. That's paragraphs 128 to 130. 2, it was held that that agency relationship could be described as a fiduciary one, importing fiduciary duties owed by the Utilitywise to my client, paragraphs 131 to 146, not challenged. And 3, it was held by his lordship below that the broker was, by reason of its relationship with the defendant and its dealings with the defendant, subject to a conflict of interest. That's paragraph 147 of the judgment. That is not challenged, and indeed Mr. O'Connor himself in cross-examination admitted that that was the case. Those are 3 important holdings of the judge below, which of course I cleave to, and it's after that, it's from that point onwards that I respectfully part company with the judge's analysis. And we say, my lady, that this is a case that is what we would describe as a paradigm Herstanger case. And all the judge needed to do to reach the right answer in this case was consider the seminal judgment, and I use that word advisedly, it's been cited, I think, 50 times with approval, subsequently to its being decided in 2007 by the High Court and indeed by this court on a number of occasions with approval. All that the court needed to do below was look at Herstanger, and Herstanger provided a clear and obvious answer to this case. And with that introduction, I propose to take this court to Herstanger, given its significance. Its authorities bundle, tab 23, if your ladyship is dealing with it on a hard copy, it's bundle 2 of the authority bundle. We can put away, for the time being, the core bundle and the supplemental bundle. And we can go to tab 23. Now, I'm conscious of the time, and I'm just going to, I hope, not too impertinently ask whether the court has had an opportunity to cast an eye over this judgment before today.
Yes.
I'm grateful. In which case, I'll take it as quickly as I can. The core facts of the case were simple. They are to be found at external page 476, internal page 2354 of Lord Justice Tuckey's judgment. The court will recall this was a case where two borrowers were in arrears on their first mortgage. They sought a second mortgage and lending under a second mortgage to repay the arrears of the first mortgage and to free up some cash. They went to a broker, Mr. Dunk, who went out and found them a lender in the shape of Herstanger to lend them the sum of money they required. And if one goes to paragraph 4, it'll be seen that the lender told the borrower, this is at D in the sidebar, in certain circumstances, this company, that's Herstanger, does pay commission to brokers and agents. And we see as well, insofar as it's able, it endeavours to ensure the broker conducts their business activities in a fair and proper manner. Echoes of the contract we saw a little earlier. And there is then the finding, which was common ground, that at paragraph 5, that Mr. Dunk, the agent of and fiduciary of the borrowers, who were the defendants in that case, because it was a claim for possession, received a commission of £240 from Herstanger. There were two aspects to the appeal. There was a Consumer Credit Act aspect, which you don't need to worry about, and there was a secret commission aspect. And the secret commission aspect starts at paragraph 30, page 483. And I think we can pick it up at paragraph 33. Certain things are clear, says his lordship. The defendants retain the broker to act as their agent for a substantial fee. The difference here is there was no fee paid by my client, whereas there was a fee paid by Mr. and Mrs. Wilson to Dunk on top of the fee paid, but that didn't seem to have any significance to the outcome of the case. The contract to retainer contained the usual implied terms, but the relationship created was obviously a fiduciary one, as here. As a fiduciary, the agent was required to act loyally to the defendants and not to put himself into a position where he had a conflict of interest, equally applicable here. Yet he agreed that he paid a commission by the other party to the transaction, which his clients had retained him to procure, equally applicable here. By doing so, he obviously put himself in a position where he had a conflict of interest. Pausing there, it might be said the conflict in this case was on a scale of magnitude far, far greater than the scale of magnitude of the £240 commission paid to Mr. Dunk by Herstanger. Going back to the judgment, the defendants were entitled to expect him to get the best possible deal, as here, but the broker's interest in obtaining a further commission for himself from the lender gave him an incentive to look for a lender who would give him the biggest commission, precisely applicable as here. So that paragraph goes a long way to creating the legal framework for an understanding of this case and for an understanding of its proper disposition, I would say. Para 34, the broker could only have acted in this way if the defendants had consented to his doing so with full knowledge of all the material circumstances and of the nature and extent of his interest. Nature and extent, I emphasise. There's a reference to Boasted, which is, that's obviously that paragraph of Boasted has now been overtaken, and it's now to be found in paragraph 6039. It's in my lady's bundle of authorities at tab 54. I don't go to it now, but the relevant paragraph, which is a very useful paragraph, I should say, is at 6039 in the court's bundle. An agent who receives a commission without the informed consent of his principal will be in breach of fiduciary duty, absolutely as here. A third party paying commission knowing of the agency will be an accessory to such a breach. We'll come on to that phrase, accessory. The remedies for breach of contract are equitable, breaches of fiduciary duty are equitable. And then there's a question at 35 as to what constitutes sufficient disclosure. there's a debate at 36 about whether the amount of the commission he is to receive from the other side is required. And there's a passage from Bosted which is quoted. Pausing there and telegraphing a submission I will make in due course. The conflict in Herstanger could be said to be in a pretty minor level conflict, given the comparatively small amount of the fee, which was of course not referable to the amount of the loan. It's just a single fixed fee. The nature of the conflict in this case was on a vastly greater scale of magnitude in my respectful submission. And as I have submitted in my skeleton argument and will submit to the court later, required disclosure of a substantially larger number of matters in order, if fully informed consent could be set up as a defence to the claim. And then we have a passage which has been quoted on later occasions at the end of paragraph 36. A statement of the amount that the lender is to receive, the broker is to receive from the lender, is, I think, necessary to bring home to such borrowers the potential conflict of interest. And that's a useful working test in my respectful submission. One has to analyse the nature and extent of the conflict that's being created in the given case. One then has to ask what is necessary to bring home that potential conflict. And that question will be, I accept, fact sensitive. There's then a reference to an OFT report where the OFT take the view that disclosure should be in writing before the borrower enters into the loan. This is at C. I accept this is not of immediate relevance to this case, but it shows the regulatory concern about broker opacity replicated in this case. Then para 38, my lady. Obviously, if there's been no disclosure, the agent will receive a secret commission. That would be a blatant breach of fiduciary duty. In addition, the payment or receipt of a secret commission is considered to be a form of bribe and is treated in authority as a special category of fraud in which it is unnecessary to prove motive, inducement or loss up to the amount of the bribe. The principle has alternative remedies against both the briber and the agent for money hadn't received. And then there's a reference to the famous case of Mahizan and the famous dictums or dicta of Lord Diplock in that case. So pausing there, in a straight case of secret commission, where there has been no disclosure at all to the principal of the fact of the commission, then the law analyses the position as against both the recipient of the bribe, as the law conceives it to be, and the payer of the bribe, as a joint and several liability in money had and received at common law, which is suable on, irrespective of the mental state of the payer of the bribe, irrespective of any dishonesty or moral turpitude on the part of the payer of the bribe, and irrespective of whether the agent was induced in any shape or form to act contrary to its interests, to its obligations, to its principle, by the receipt of the bribe. These are all, as the court will be well aware, and my lady, of course, will be well aware, given her role in Conway and Easy, which is a very significant case on the law of bribery, if I may say so, with respect. But that is the clearly established law.
But you're not saying that the instant case is a case of a fully secret.
I'm not. That was conceded at first instance, and I don't think I can go behind that concession. But this is to use the nomenclature of Herstanger, a halfway house case. As I'll come on to show, where we're in a half secret case, the only impact of that is to mitigate or reduce, or circumscribe, I should say, the remedies available to the claimant, as we'll come on to. But pausing at a bribery case, the classic bribery case of X paying Y being Z's agent, a sum of money which is in some way referable to a transaction, all that needs to be proved to hold the payer of the bribe liable in money had and received for the amount of the bribe is knowledge of the agency. That's all that needs to be proven. That's the only mental state that needs to be established by the claimant in a claim for money had and received against the briber.
But that's not the situation here.
that, well, it is actually, as I'll come on
Well,
to show.
and then at 39, Lord Justice Tuckey says, where there's been only partial or inadequate disclosure, it's sufficient to negate secrecy. It would be unfair to visit the agent and any third party involved with the finding of fraud and the other consequences to which I've referred, etc.
Ah, yes, quite right, my lady. Or conversely, to acquit them altogether for their involvement in what would still be a breach of fiduciary duty unless informed consent had been obtained.
Absolutely.
Just pausing there, the common feature, it's an integral part of my submission, that secret commissions and half-secret commissions are not wholly different legal conceptions. They flow from a single legal conception, which is the law's concern about the subordination or the potential subordination of fiduciaries or agents.
So how can that, I mean, paragraph 38 seems very clearly to distinguish between a case in which there is no disclosure, italicised, first sentence,
Yes.
38, and a situation where there is some disclosure, but just not enough.
So
you say there's in fact no difference, but
I
how
don't
do
say
you explain paragraph 38 and 39?
I don't say there's no difference. I say that the underlying principle of the law that is engaged is the same in both cases, and that is the law's concern to ensure that fiduciaries and agents are kept to their duties of strict loyalty to their principle. And we see in all the cases, repeated time and time again, that the underlying mischief of a bribe is its tendency to create a conflict between duty and interest. And of course, the tendency
Sorry,
of...
but I think you're going off a little bit on that. Just a second. Let's assume that there's a clear breach of fiduciary duty. As I understand it, the difference between the sides in the instant case is that if there is no disclosure at all of a commission, then the breach of fiduciary duty is regarded as falling into a special category of fraud where you don't need to prove motive, inducement or loss.
Or constructive fraud. I think it's...
Yeah, okay. I'm just reading the words.
Yeah.
Up to the amount of the bribe, and therefore you don't need to have any state of knowledge to recover from the payer.
Other than knowledge of the agency.
Right. But where there is some disclosure, but just not enough to prevent it being a breach of fiduciary duty, so it is still a breach of fiduciary duty, you can't fit within the category of cases referred to in paragraph 38, and you are in the category of cases which were other category of cases referred to in paragraph 34, where your claim against the third party is as an accessory.
Well, can we come on to...
And that, it said, requires dishonesty.
Let's come on to 39.
But have I got the measure of the difference between the parties?
Well, that's the difference in the parties at the bar. But Hurst-Anger itself shows that in a so-called half-secret case, the actual ingredients for liability are the same. Merely knowledge of the agency, as I'll come on to show. Where the difference lies is solely in the remedial response of the courts to the breach of fiduciary duty. So if we go back to 39, Lord Justice Tuckey says that where there is not secrecy in its absolute form, it would be unfair to visit the agent with a finding of fraud, but it would not conversely be appropriate to acquit them altogether for their involvement in what would otherwise still be a breach of fiduciary duty.
His reference to the finding of fraud is surely a reference back to the category of cases that he referred to in paragraph 38.
Which is a finding of constructive fraud, yeah.
Yes, okay.
Quite right, with respect. Then we go on, there's a reference to Bartram, which I don't think we need to worry about. We then go on at page 486 to the court's consideration of the facts of that case. Had there been any form of disclosure, there's an analysis of all the submissions, a consideration of the submissions that were advanced. We get to paragraph 42. The only disclosure, this is 3 lines down, made to the defendants was by means of the claimant's documents which the defendant signed. That's the document I showed you, quoted at paragraph 4. By signing the document, which came from Herstanger, the defendants, i.e. the borrowers, must be taken to have understood what it said, but no more. Quite apart from this, the passage from Bodestead, which I've cited, says that it is for the agent to establish that sufficient disclosure has been given. Here the claimant, that's i.e. the defendant in this case, knew that the broker was the defendant's agent, and so it had to show, Herstanger had to show, as the payer of the commission, that it paid commission to him in circumstances where its borrowers had given their fully informed consent to such a payment. So, with knowledge of the agency, it was for the claimant to demonstrate fully informed consent. The question is whether it did so. And then paragraphs 43 to 45 consider that question. Yes, secrecy had been negated. If you tell someone that something may happen, then secret is out. But then at 44, was the defendant's informed consent obtained? I do not think so. The passage which I quoted was muddled, and one might say here the muddle is apparent in spades. Although read carefully for the reasons given by Mr. Seymour, it may not in fact have been ambiguous, but it could and should have been made clearer and informed the defendants and so on to the end of paragraph 44. So fully informed consent was not proven by Herstanger, the burden being on it. Hence it was a halfway house, para 45. The claimant didn't pay the broker a secret commission, but procured the broker's breach of fiduciary duty by failing to obtain the defendant's informed consent to the broker acting in the way it did. Now, pausing there, it's right to say that in Johnson, the court quibbles with the last 2 lines of that, but not in a way that's material to the underlying decision in Herstanger, because it says, in fact, the procuration was not a failure, but was in fact the payment of a commission which created the conflict. So all that is required to establish the liability recognised in Herstanger is 2 features. 1, knowledge of the agency, tick. 2, payment of a commission which creates a material risk of breach of conflict of interest or duty. Tick. Both found by the court below and not contested. That is sufficient to found the liability of procuration which is relied upon which is referred to at paragraph 45. And one can well see why. Because after all, the only reason the agent is subject to a conflict, the only reason the agent is placed in breach of its fiduciary duties to my client is because the defendant, Engie, has made an elective decision to pay a commission to the broker, and in the circumstances that we have seen. Engie has created that conflict. It didn't need to do so. As Johnson sets out in great detail, there are all sorts of steps that the supplier, whether it's a bank or an energy supplier, can do to ensure there is no conflict. But it didn't do so.
Now, as the Court of Appeal in Johnson pointed out, there's an obvious tension, I'd say worse, there's a conflict between this passage you're looking at, interpreted in light of your submissions, and the traditional law on accessory liability for breach of fiduciary duty. And we're only here talking about accessory liability for breach of fiduciary duty, as I understand it.
No, my lord, we're not. The word accessory is used only once in Herstanger, and that is at paragraph 34. At paragraphs 45 and 48, where we find the ratio of the case, where we find the actual working out of the constituent parts of Herstanger's liability, Lord Justice Tuckey is punctilious to use the word on 2 occasions, procuration. It is not, I would say, properly so described, an accessory liability. It is a primary liability founded on the fact that the supplier has electively decided to create the breach of fiduciary duty and the conflict, and has done nothing to cure that breach or cure that conflict by providing full information to the customer that would provide the transparency that is required to cure and ratify the breach.
So this is not, I say it's only related to fiduciary duty because in our case, that was the only case advanced at trial. There's no case advanced in contract and therefore no case advanced in procuring breach of contract.
In this case?
In this case.
There was a case advanced in procuring breach of contract, but the position was taken at trial that it was no more than a simulacrum of the actual case I'm now.
So what we're concerned with in this case is a breach of fiduciary duty by UW, and as is foreshadowed at 39 of Lord Justice Tucky's judgment, Engie in this case is not acquitted altogether from their involvement in what would still be a breach of fiduciary duty. Now, traditionally, one is liable for involvement in someone else's breach of fiduciary duty if you have assisted that breach of duty, and that's the classic dishonest assistance in breach of duty.
Yes.
You're saying, however, that's not the basis of the decision in Herstanger?
I'm saying it's not because it's absolutely clear that the liability that is recognised by the Court of Appeal, and Lord Justices Jaker and Waller agreed with Lord Justice Tucky's judgment, and I noticed that permission to appeal was refused by the House of Lords over the page, the liability that is recognised and generates a remedy in favour of the borrowers in that case is not dishonesty based. It's explicitly not dishonesty based. The word dishonest doesn't appear in the judgment. There are no findings of dishonesty or anything approximating to dishonesty by Lord Justice Tucky. The ingredients of the liability are knowledge of the agency and payment of the commission. And we see that at paragraph 48, bottom of page 487.
Where does this come from then? I mean, this appears to be an entirely new concept of procuring a breach of fiduciary duty, which is not dishonest assistance in a breach of fiduciary duty.
Well, well, let me answer that question in 2 ways. First of all, it's a decision which has been applied without any form of disapproval over the last 20 years by, I think, 55, I think it may be. I mean, the precise number doesn't matter.
Well, except in Johnson, where it was doubted, and in
Well,
fact it was accepted that
no, I don't accept
dishonesty is required.
With respect, I don't accept that. A concession was made,
Yes.
which was a concession which should never have been made, and the court were effectively led via that concession into an analysis, which, I mean, in fact, as we'll come on to see in Johnson, the analysis that they arrive at, notwithstanding the concession, is basically a simulacrum of what Lord Justice Tucky.
Well, it's a finding of dishonesty.
Well,
let's be clear.
it's a finding of dishonesty based on essentially the same 2 facts: payment, knowledge of the agency, and payment of the commission. And let me just make good that point straight away. We go to Johnson, tab 50. This is bundle 4 of the authorities, if one is in hard copy. It's tab 51, para 138. Well, you can pick it up at paragraph. Let's take the whole thing in one go. We go to para 124, page 1389 of the external pagination, page 32 of the internal pagination. There's a reference to Herstanger at 124. Mr. Weir, who was leading counsel for the customer appellants in that case, reserved a right about the nature of the liability. Unfortunately, none of the parties addressed the issue on which was necessary or what was needed to found accessory liability in their skeletons. No findings were made by the DDJ or the judge on appeal about first round state of mind, because they wrongly found there was no fiduciary duty. pausing there, can I just explain that I've seen the pleadings in Johnson, which was the only half-secret case. The other two were held to be fully secret cases and therefore could be determined simply by reference to a claim of money having received. The pleadings involved no allegations of dishonesty whatsoever against First Rank, I should say. Then we have the reference to Herstanger at 125, where it is accepted that Lord Justice Tuckey's formulation of the liability was not dishonesty based. It is accepted, and rightly so, that Lord Justice David Richards, as he then was in the seminal case of Wood, decided in 2021, had endorsed the analysis of Lord Justice Tuckey.
So can I just pause there, because it's at the beginning of 125, the point's made that Herstanger is the only case where the lender's liability was an issue. So you're to say that the Herstanger has been approved in many, many other cases. This particular issue has not, has it, in a case in which it mattered?
I think it might, that may be, I mean, maybe McWilliam did actually endorse the full analysis, but I mean, it's cited without anyone suggesting that the liability in Herstanger, my lord, it's at the centre of the case. The nature of the liability, it's not some adjectival or extraneous decision round the edges of the ratio. It's at the heart of the ratio of Herstanger. Lord Justice David Richards endorses it, and of course, and then we see what paragraph 126. Then I think my lord was thinking about paragraph 127. Not altogether straightforward to reconcile the approach in Herstanger with the leading authorities concerning the mental state. And then we have Mr. Weir, in what circumstances he did so, I do not know. But in argument, because he didn't make this concession in his skeleton argument, because I've seen it, except that in order for there to be an accessory liability in equity for assisting in a breach of fiduciary duty, the defendant must act dishonestly. And then, quite remarkably, I would say, with the greatest respect, in Twin Sector and Yardley, as if the law of dishonesty had been sitting in Aspic, this is a separate aspect of my submission, of course, since 2002, and as if Mr. Weir hadn't read a judgment in which my lady participated, and a very important judgment, of course, in Group 7, or Barlow Clowes, or Ivy and Genting. That may be a slightly different point. But my learned friends seem to think the law of dishonesty in dishonest assessment stops at Twin Sector. They cite it for 2 pages in their skeleton argument, quoted at length. I was going to tell your lordship, though, why, having accepted that concession, the court then goes through quite a detailed analysis of the nature of the dishonesty required to be proven and arrives at an outcome which is really no different to the Herstanger outcome. And one can see that in paragraph 137. I mean, one can see it throughout the relevant paragraphs. I haven't got time to take you through them. 137. In a halfway house, which we must assume Johnson to be for the purpose of the issue, the fact that there is no informed consent follows automatically from the finding there has only been partial disclosure. And that on that analysis, the lender must be liable as an accessory for procuring the breach of duty. This appears to be consistent with the decision in Herstanger. And then only if that is wrong is there further consideration of the state of mind of the lender. Because the primary facts the lender needs to know, or the supplier in this case, to found the liability, whether under Herstanger or as analysed in Johnson, is knowledge of the agency and payment of the commission knowing that fully informed consent had not been obtained by it. And my lord, the matter is put beyond doubt if one goes to paragraph 173, page 1402 of the authorities bundle, little 3 at the bottom of the page, where, in conclusion, if there is a fiduciary duty in a partial disclosure case, as here, What are the necessary ingredients to establish accessory liability on the part of the lender? Answer. Knowledge of the existence of the fiduciary relationship, tick, here, and payment of the commission to the broker in circumstances in which the lender, for lender read supplier here, has not satisfied itself that the borrower has given their fully informed consent to the payment. Those circumstances will inevitably arise if the disclosure is partial, particularly if the lender has encouraged partial disclosure. My lord, it all comes to the same thing. And that is why, my lord, Mr. Lord, in his skeleton arguments, is driven to argue, because he has to, if he is to uphold this judgment on appeal, that both Herstanger is wrong, see paragraph 46 of his main skeleton argument, and also that Johnson's wrong. See para 121, see para 16 and para 27 of his supplemental skeleton argument. And my lord may think that's quite a high hill to climb, to persuade this court that two judgments by which it is banned through some process of precedent that I'm not aware of should be simply set aside and departed from. My lord, it is vital to understand that even though Mr. Weir made a concession which he should never have made, the actual working out by the Court of Appeal over a number of highly detailed and closely reasoned paragraphs from para 127 through to para 141 of Johnson leads us to a conception of dishonesty which is precisely the simulacrum of the basis of liability held by the Court of Appeal in Herstanger. All roads lead to the same outcome. And that is obviously right, assuming the concession was rightly made, which I don't accept, because if one guides oneself as one should, by reference to my lady's judgment in Group 7, which has evaded my learned friends, but which I suggest is the last word and the most important word on this subject, we will see that, as I hardly need tell this constitution of the Court of Appeal, that in order to establish liability for dishonesty and dishonest assistance, which this is not, and I'm going to come back to that, one need engage in a two-part or two-pronged approach. One, findings as to what the person charged with accessorial liability knew. Here we have all the findings. We have the finding of the judge that they knew there was an agency relationship. We have the finding of the judge that Mr. O'Connor knew that there was a commission being paid, is perfectly obvious, and that it created a conflict. O'Connor accepted that. It created a conflict. We have, if necessary, and it's actually not necessary, but for good measure, we have the finding, as conceded by Mr. O'Connor, that he knew the broker would not disclose the facts about the commission to the agent, to the principal. And finding 4, so far as it's necessary, which is not, is that the lender, contrary to what is said in Johnson, had taken, the supplier in this case, had taken 0 steps to bring home the conflict and to create transparency itself, bar, my learned friend would stand up and say, if he wanted to now, don't forget the contract. And of course, your lordship and my lady will remember that, those elliptical words in that boilerplate provision, which is almost impossible to actually read, in the contract. Brackets which were not sent to Mr. Gaisley, close brackets. So once one's gone through the first stage mandated by Ivy and Group 7, viz. Establishing the state of mind of the alleged dishonest assister, assuming that's the right analysis, which it's not, one then asks, objective stage 2, by reference to ordinary standards, was that dishonest? And the Court of Appeal in Johnson were emphatic that and a lower level of knowledge was dishonesty for the purposes, constituted dishonesty for the purpose of the claim in dishonest assistance. I wind back, if you give me 3 more minutes to answer this particular point, I wind back to the question that my Lord Justice Zacaroli posed to me 10 minutes ago, which is, well, is this just not a claim in dishonest assistance? No, it is not a claim in dishonest assistance, and Lord Justice Tuckey made that patently clear in his formulation of the ingredients of the liability. Let us finally go to paragraph 48.
48 of.
I do apologise, of Herstanger, tab 23,
Yes,
bundle
got it.
2, page 487,
Yes, I have
external
it.
pagination. This is not a claim, says Lord Justice Tuckey, with the agreement of Lord Justice Jacob and Lord Justice Waller, I should say, in a claim for money hadn't received. It's not a claim at law, but it is its equitable simulacrum. The defendants have a claim for equitable compensation against the claimant as it procured the broker's breach of fiduciary duty. This mirrors the common law right to claim the return of a bribe as money hadn't received. So the actual remedial response of the court to the facts as found, even though placed into an equitable envelope rather than a common law envelope, was precisely the same and involved precisely the same constituent facts. The one point of difference between the remedy at common law and the remedy at equity was that because this was a halfway house case, it would be wrong, said the Court of Appeal, to permit the defendant, quasi-claimant, the full panoply of common law remedies, and as the court will know, at common law, the right to rescission, if the facts are found to justify rescission, is not a matter of court intervention. It is a matter of right that can be accomplished by a form of self-help by the claimant, whereas in equity, of course, the remedy of rescission is discretionary, can be withheld in the right cases, or can be moulded to the justice of the case. And all that differs between the Herstanger liability and the Mahesen liability, if I can so call it, the only point of distinction, there's no distinction in reality in terms of the ingredients of the claim, is the remedial response of the courts. In Herstanger, Mr. and Mrs. Wilson had rescission as of right withheld from them. It's a discretionary question because we're in equity, and the court took the view that one can see why a £240 commission to rescind the entire contract and mortgage could be seen from a person of the world point of view as overly as a disproportionate response to the wrong. Hence, it was an equitable position, and the court withheld rescission and instead granted what was exactly the same in outcome as a Mahesen money hadn't received liability upon the payer, who, I mean, Mahesen accepts there's some doctrinal complexity or oddity about a claim for money hadn't received against the person who'd actually already paid the bribe, but that's, as Lord Diplock put it, that debate has well passed. It was decided many years earlier. This is the law, says Lord Diplock.
The only difference, in fact, is the circumstances in which the remedy of rescission is available.
That's not just a submission by me. It's just that's what it says on the page. Yeah, exactly right, my lord. That may be a convenient moment. I'm sorry to have slightly.
Just while I remember to ask you, I think in the middle of that, you referred to either evidence or a finding to the effect that Mr. O'Connor knew that the broker wouldn't disclose the amount of or disclose the commission to the customer.
Right. Page, can I take you straight to it?
Unless I've missed it, we haven't been taken there. And I don't need it now. It may well be.
I know it.
But that's one bit of the factual jigsaw for whatever it's worth that we haven't been seen.
May I give you the reference? Because page 81 and 82 of the supplemental bundle. And if I can trouble the court for one more minute just to answer this, to make good this point. This is counsel then appearing for the claimant. Little e on the sidebar, he quotes from a decision called the Dark Blue Pig, which is another case against Engie, where Mr. O'Connor had given evidence. He quotes from the judgment, which we have in the bundle. Mr. O'Connor said he could not comment on the rationale behind clause 4.11. That's the brokerage agreement. You've got to be transparent, you know, blah, 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 which I showed you, which my learned friend relies upon. But that in his extensive experience in the industry, he would not have expected a broker like Utilitywise to tell the customer about the fact and amount of commission, though he would expect a customer to be aware that there was a commission, i.e., and this is the phrase I perhaps was slightly over-strident about, being transparent did not mean disclose. And that was the evidence in that case, was it not, says counsel? Yes. So the averral in the defence, which says, oh, we expected the commission to be told, all the facts about the commission to be told by the agent, that's in the Engie's defence in this case, which says you assumed you disclosed the amount of commission, is not consistent with your evidence. You can read, my lords can read on, yes. And then it goes on, I don't want to trouble the court any further, but then it goes right to the bottom of the page. There's some debate about, but there's not debate, it's just driving home the point. And then my question in a later case called Weardale, when I was appearing as counsel for the claimant in that case, a different claimant, same defendant, same broker, I then asked a question, apparently at G and H. I'm making a narrow question. I'm going to ask this again. Why is it, Mr. O'Connor, in your extensive experience in the industry, you would not expect a broker like you? And you can read on. Your answer was because that was now, that must be how.
So I've lost where you are.
Page 82, this is external page 82, bottom of the page, Mr. Brown, G and H. Where Mr. Brown quotes a question from me in an earlier trial, not Dark Blue Pig, a case called Weardale, quotes my question, quotes Mr. O'Connor's answer back to me. I hope that makes good the point. I'm sorry to trespass further onto your lordship's
My lady, it's not the best moment to bob up at 5 past. But can I just invite my lady and your lordships to look at page 82, which we were on, that was passed over by my learned friend C, where he says, if they were asked, I would have expected them to sort of responded in an honest manner. And that is echoed in the judgment of His Honour Judge Saffman at paragraphs 109 and 190, where he finds that if they'd asked, they would have been told.
Thank you, Mr. Lord. Thank you. We'll resume at 2 o'clock. And as I've mentioned a couple of times already, I'm quite concerned about timing, given that we have a lot of ground to cover.
Court rise, please.
I think Hopeless are coming back to try and sort this out. So they need to come back in, don't they? Yeah, lock that door. No, I need to come back. They're out, they should be out there.
Mine asked them.
They're there. It's not working.